If you did not give consent after arrest for a blood test, typically what would happen in Marin County is that they would get a warrant, do a forced blood draw, and then they actually can use the results of that test against you. They are allowed to do that. If it's a situation where they decide not to do the blood test because you're struggling too much, or they don't have a phlebotomist available, or officers around that want to hold you down. We were seeing a lot more of these cases during COVID where the officers just didn't want to get that close to somebody. But if that does happen and no blood test happens, what evidence do they have to use against you in a DUI drug case? Well, there's a few things. One is they will do what's called a DRE examination. They'll get a drug recognition expert who's usually a CHP officer who had extra training. The training and their whole, predicting what you're on is pretty sketchy, and it's something that we can definitely attack, especially getting their rolling logs and things like that, where we can show that their knowledge is not what they're putting it out to be, that they're not these specialized experts. They've had some extra training, but we can attack their reports. If they are testifying, we can definitely make some waves there in a trial situation. The things that they're using are, the field sobriety tests. If you did submit to them, the DRE, it's a 12-step test that they have you do. They in addition to like field sobriety tests, the walk and turn and standing on one leg. I'm sitting here standing on one leg. Obviously, you can't see my leg because you can only see my upper body. But the horizontal gaze and nystagmus tests, they'll do all those. They'll also check pulse. They'll check the rigidity of your skin. There's a number of other tests that they do. They'll put you in a dark room. They'll check your pupils. And then they'll do all the regular field sobriety tests as well over again. And then they'll try and predict what you're on. One of the things that they do is they will first ask you what or if any drugs that you've taken. And then at the end of the DRE examination, they need to predict what drug you're on. And obviously, if someone said that they took heroin, they're going to say, well, this person appears to be on heroin. Again, it's some would call it junk science. There is some accuracy sometimes, but it's one of the most inaccurate types of testing ever produced for courtrooms. And I don't want to call it a joke, but many would. It's pretty close to that when it comes to, complete scientific testing and accuracy, which we as citizens and in juries want to see. So those are some things that can come up to that the DA can use to try and convict you if there have not been, if a drug test was not done. Other things that they can do is they can look at the driving. They can look at, video and talk about your demeanor. They can talk about your speech, your eyes, your balance, and also they can use what you told them. If you told them that you had done certain drugs or taken certain medication or mixed it with alcohol or whatever, they can use a lot of that stuff against you. So, in these situations, if you decide not to do a test, which for a lot of reasons is not always a smart way to go, but if you do go that route, then the best thing that you can typically do is really not give them any evidence, not answer the questions other than, give them your license and that just information about you that they need, but anything about what you took, when you took it, what when you ate, when you last, all that stuff, you're not required to give them that information. The more you give them, the more they have to use against you. So telling a police officer in Marin County that, you respectfully decline to answer their questions is allowed. There's nothing wrong with it. It's not an admission of anything. It's just you have been told, by a lawyer that you're not required to give them anything. And the only thing that you're really required to do if you have been, or once they arrest you for a DUI, is you are required to do either a breath or blood test, or if they think it's just drugs, they won't give you the option of a breath test. If they do and you've only had drugs, a breath test is going to be a lot less conclusive than a blood test. But if you do refuse to do that chemical test after arrest, once they've properly admonished you, then you will lose your license for a year. And we can fight for that. It's a very difficult uphill fight. We've won a lot of those cases, especially with DMV, but there's no promise or guarantee there. So refusing a test is often going to be more problematic for you, especially if you really need that driver's license.